Hello viewers, I am Dr. Shivani Gupta from the University Institute of Legal Studies, Punjab University, Chandigarh. It is my pleasure to welcome you to this session on an intriguing topic in the law of property, that is transfer of property subject to mortgages. This topic delves into the fascinating interplay between mortgages, their creation, their types, and most importantly, the type of rights and duties that bind the parties to the transaction. A mortgage is the transfer of a borrower's interest in real estate to a lender as collateral for a loan or other debt. Mr. Sharma, for example, needs a loan for constructing his house. For securing the loan, he transfers an interest in his plot of land in favor of the bank from which it is seeking the loan. This transfer of interest in the bank is called a mortgage. In the event of the mortgager defaulting on his financial commitments, this conveyance gives the mortgagee the power to take control over the property. If Mr. Sharma is not able to pay back his loan within the stipulated time, the bank shall have the right to take control over the property mortgaged and can even sell the same to recover its loan. The legal framework governing the establishment, rights and obligations of parties participating in these transactions is established under the Transfer of Property Act. The Transfer of Property Act of the year 1882 addresses mortgages under the provisions contained in sections 58 to 104. According to section 58, a mortgage is the transfer of an interest in real estate as collateral for a loan, a current or potential debt, or the fulfillment of a duty that could lead to financial liability. The person who transfers the interest in such real estate is known as the mortgager, and the person to whom such interest is transferred is called as the mortgagee. In order to obtain a mortgage, an interest in real estate must be transferred. The mortgagee receives a fractional stake in the property as collateral for the loan, but the mortgager still owns the entire property. The main amount plus any interest that is now secured is in now totality termed as mortgage money. Therefore, mortgage money is the principal amount that a borrower receives from a lender with the real estate serving as collateral. The principal amount in this context refers to the principal amount borrowed, which is indicated in the mortgage deed and secured by a mortgage or hypothecation. This whole transfer is effected with a legal document known as the mortgage deed. Next is the crucial points involved in a mortgage. First one is interest is transferred to the mortgagee. Second, the interest must be related to a particular piece of real estate or immovable property. Third is the mortgage transaction needs to be supported by some consideration. As per section 58 of the Transfer of Property Act, there are 6 types of mortgages, each having unique legal ramifications. The first category is a simple mortgage. A simple mortgage, as defined in section 58B of the Act, does not entail the transfer of real estate to the mortgagee. Rather, the mortgager agrees to return the mortgage funds and the mortgagee has the right to sell the property in the event of default and utilize the revenues to pay off the obligation. Next is mortgage by conditional sale. A mortgage by conditional sale as defined under section 58C permits the mortgagee to sell the property in case if the mortgager is unable to make the mortgage payment by a given date. However, the sale is nullified and the mortgager regains title upon the payment of loan. Next is usufructory mortgage. In a usufructory mortgage, the mortgager gives the mortgagee possession of the property in accordance with section 58D. In order to modify the interest, the mortgagee may keep ownership of the property until the loan is paid off and may also collect the usufruct or profits from the property. English mortgage. According to section 58E, an English mortgage occurs when the mortgager gives the mortgagee ownership of the property with the understanding that the property would be returned to the mortgager upon repayment of the mortgage funds on a certain date. Next category, mortgage by deposit of title deeds. This kind of mortgage as defined by section 58F arises when the mortgager deposits the title deeds of real estate with the creditor as security in the designated municipalities that the state governments have informed. Last category is anomalous mortgage. According to section 58G of the Transfer of Property Act, any additional category or type of mortgage that is not specifically mentioned above is considered as an anomalous mortgage. Now, with the passage of time, another category has crept in, that is called as the equitable mortgage. This mortgage does not find recognition under the Act as it is created without following the procedures that the Transfer of Property Act specifies must be followed in order for a mortgage to be considered as lawful. Thus, it is a mortgage when a property owner pledges his property to a lender in order to obtain a loan without subsequently executing a formal mortgage deed. It is based upon a mutual understanding or agreement between the parties, which might be evidenced by the deposit of title deeds or some written document that sufficiently demonstrates a desire to establish a mortgage. It is thus enforced by the courts through equity based on the grounds of justice and fairness, and a decree or order may be properly issued against the mortgager in favor of the mortgagee. Law says, then whenever a property is mortgaged, there are attached a few rights that the mortgager gets with such transfer. Following are the mortgager's rights. First is the right to redeem. The mortgager is entitled to redeem the mortgage in accordance with section 60. Redemption means to reclaim. It is the right of the mortgager or borrower to recover legal possession and absolute ownership of the property from the mortgagee or lender upon full payment of the due debt. Mr. Sharma, for example, gets a home loan According to his mortgage deed, he has 20 years to pay back the principal amount plus interest that has accumulated. In the allotted time, Mr. Sharma manages to pay back the full amount. By formally notifying the mortgagee of his desire to redeem the mortgage, he can now use his right to do so against the mortgagee. The mortgagee releases the mortgage and returns the house's legal title and possession to Mr. Sharma upon receiving the final settlement. This procedure is called redemption. As a result, by giving the mortgagee the money that is due on the specified date, the mortgager can reclaim the mortgaged property. No agreement can take away the right to redeem, since this is a statutory and legal right. Next is right to directly transfer to a third party. The mortgager may direct the mortgagee to assign the mortgage debt and transfer the property to a third party in lieu of the mortgage, as permitted under section 60A. The purpose of this clause is to allow the mortgager to pay off the obligation by obtaining a loan from another individual secured by the same property. Right to inspection and production of documents. The title documents of the mortgaged property in the mortgagee's possession may be inspected at any time by the mortgager in accordance with section 60B of the Act. The mortgager is responsible for covering the cost of the inspection. Next is right to accession. If you have a mortgage and you make improvements to the property while you still own it, you are entitled to keep the modifications after you have paid off the mortgage as per section 63 of the Act. Whether the additions occur organically or are acquired in some other way is irrelevant. Next, right to improvements. You still have the right to keep whatever modifications you make to the property while the mortgagee is in possession of it when you eventually pay off the mortgage, according to the provisions given in section 63A of the Act. There is a catch. You will have to pay back the mortgagee for whatever renovations they made to keep the property from being destroyed. Next, right to renewed lease. After you have paid off the mortgage, you are eligible to take advantage of the benefits of that renewed lease in accordance with section 64 of the Act. Next, the right to grant a lease. Property that is legally in the mortgagee's possession may be leased out by the mortgager in accordance with section 65A of the Transfer of Property Act 1882. If such a lease satisfies the following requirements, it will be legally binding on the mortgagee. First is, local laws, customs or usages must be complied with in the lease. Second, there will be no upfront rent or premium payments. Third, a clause allowing for renewal cannot be included in the lease. Fourth, the lease will go into effect 6 months after it is signed. Next one, the lease term cannot be longer than 3 years in the event of building lease agreements. Since rights and duties coexist, wherefore, if the mortgager has the above mentioned rights, he is even obligated to comply and fulfill the following liabilities as contained under section 65 and 66 of the Act. Thus, following are the liabilities of the mortgager. First is covenant for title. There is an implied covenant under section 65A of the Act that the mortgager guarantees that the title given to the mortgagee is transferable and belongs only to the mortgager and none else. The mortgager is responsible for damages in the event that this covenant is broken. Next is covenant for defense of title. The mortgager is impliedly required to defend the title against any challenge or to help the mortgagee defend the title in accordance with section 65B. All costs associated with defending the title are borne by the mortgager. Next is covenant for payment of public charges. According to section 65C, the mortgager agrees to pay all applicable public costs at the time the mortgage is executed. If these charges are not paid, governmental authorities may sell the property to recoup the costs. Next, covenant for payment of rent. If the mortgaged property is leasehold, the mortgager is required to pay the property's rent in accordance with section 65D of the Act. Further, covenant for discharge of prior mortgage. According to section 65E, the mortgager is impliedly required to pay off any previous mortgages. Subsequent mortgagees are assumed to have a commitment with the mortgager to repay the mortgage on time. If this isn't done, the next mortgagee can sue for the money owed. Next is mortgager's liability for waste. According to section 66 of the Act, the mortgager is impliedly obligated to refrain from any actions that could cause damage or destruction to the mortgaged property. Additionally, the mortgagee is prohibited from taking any actions that will reduce the value of the property. The following are examples of the mortgager's waste. First is taking expensive fixtures out of the property that is mortgaged. Second, selling the materials and tearing down the mortgaged building. Third, removing timber from the property that is mortgaged. Fourth, the stability of the mortgaged building is at risk due to mining beneath it. Fifth, starting fresh mining activities on the property that is mortgaged. Since there are two parties involved in the transfer by mortgage, so just as there are rights and liabilities of the mortgager, the law also puts out specific rights and liabilities of the mortgagee. Here, we discuss the rights of mortgagee in possession. The first one is right to foreclose or sale. The mortgagee, that is the lender, has the authority to foreclose or sell the property if the borrower, that is the mortgager, does not repay the mortgage by the scheduled date and has not redeemed the property. Any unique conditions that both parties agree upon may apply to this right. Next is right to file for a deficiency judgment. The mortgagee may use it as a remedy in the following circumstances. If the mortgagee forecloses on the property after the mortgager is unable to make mortgage payments, the property will be sold on the open market to recoup all or part of the loan amount. The mortgagee has the right to file a deficiency judgment if the revenues of the sale are consistently insufficient to cover the full amount owed on behalf of the mortgager. It is a legal remedy that enables the mortgagee to obtain from the mortgager the deficiency. Such a deficiency judgment can only be pursued if it is so allowed under the provisions in the mortgage contract or under the local laws. Next is the right to sue. Section 77 of the Act, also referred to as receipts in lieu of interest, states that the mortgagee has the right to sue the mortgager for the money owed in under mentioned specific situations. And what are the situations? First one is after the mortgager has committed to repaying the loan. Second is if the mortgagee is not at fault for the destruction or damage to the property. Third, in the event that the mortgager unlawfully seizes the property resulting in a loss of security. Fourth, when the property is not returned over by the mortgager. Next is the right to sell. Section 69 specifies that the mortgagee has the right to sell the property in the event that the mortgager defaults on payments. There are various circumstances in which this can be accomplished without appearing in court. The mortgagee, however, must serve a formal notice to the mortgager allowing them a minimum of 3 months to resolve the matter. Also, at least 3 months must have already passed since the mortgage was last paid, and the arrears must have totaled above or equal to the value of INR 500. Next is right to appoint a receiver. The mortgagee may also designate a receiver in the event of a sale. This receiver will assume responsibility for the property and manage it in accordance with the conditions outlined in the mortgage deed. With the mortgager's approval, the mortgagee may select a substitute receiver in the event that the first one is unable to perform the duties. The receiver can deal with land revenues, taxes, rents and other property related costs like purchasing real estate insurance. Next is right to accession to mortgaged property. The mortgagee is entitled to any additions made to the property after the mortgage date if the mortgage agreement contains a clause to that effect. Next, right of mortgagee to spend money. For preventing the property from being destroyed, forfeited or sold, the mortgagee is also permitted to spend some money. Expenditures can even be made for preserving the property's title, for the mortgager and for property's insurance. Next point, right to proceeds of revenue sale or compensation on acquisition. Section 73 subsection 1 stipulates that the lender may recoup the mortgage funds from the sale proceeds of a mortgaged property sold by the government due to unpaid bills. Similarly, section 73 subsection 2 clarifies that if the government acquires your property under the Land Purchase Act or Land Acquisition Act and compensates you, the lender may deduct the mortgage funds from the payment received. Next, liabilities of mortgagee are contained under section 76 that illustrates what a property loan holder must do when taking care of someone else's property. The first one is duty to manage the property. It is necessary for the mortgagee to manage the mortgager's property with appropriate care. With the exception of the restriction that leases cannot last longer than the mortgagee's interest in the property, the mortgagee has complete management authority over the property. Next is duty to collect and to apply rents and profits. Rents and earnings from the property may be collected by a mortgagee who is in possession. Notably, the mortgagee keeps the earnings and rents under a usufructory mortgage rather than using them to pay off interest. This provision also outlines how the mortgagee in possession is to apply rents and profits earned throughout the mortgage period. Duty to pay rent, revenue and public charges. Rents, revenue, taxes and other property related fees must be paid by the mortgagee unless otherwise specified in the mortgage agreement. The benefits of the property cannot be enjoyed by the mortgagee if these financial obligations are not met. The mortgagee may utilize personal funds and then debit the amount from the mortgage account if the revenue from the property is not enough to pay these costs. Duty to make necessary repairs. The mortgagee is required to make the necessary repairs to the property as specified in the mortgage contract. Profits and excess rent are used to fund these repairs. Next is duty not to commit destructive acts. The mortgagee is required to abstain from any actions that could harm the property or reduce its value while in possession. He is, however, not liable for damage caused to property due to acts of God. Next is duty towards proper use of insurance money. The mortgagee is required to apply for and use insurance benefits for the restoration of the mortgaged property if it has fire insurance. Next is duty to keep accounts. The mortgagee is required by law to keep thorough records of all earnings and outlays related to the mortgaged property. If revenue exceeds interest, there is an exception that relieves the mortgagee of the need to provide a complete report in the event that there are no extra funds. These duties ensure that the mortgagee responsibly manages the mortgaged property and fulfills their contractual and statutory obligations towards the mortgager. A mortgagee's sale agreement's role in transferring ownership following foreclosure. A mortgagee's sale deed is extremely important in transferring property ownership following the foreclosure process. It serves as a legal document that transfers ownership from the mortgager to the buyer in the event that the mortgager fails on the mortgage and the mortgagee chooses to sell the property in order to recover the loan. It gives the buyer complete ownership and full rights to the property. Strict adherence to the legal standards is required for the mortgagee's selling deed. It involves adhering to the contents and provisions of any specific restrictions of the mortgage deed or the statute, as well as procedural requirements including public notice, auction procedures, etc. The buyer's legitimate rights and interest in the property are fully protected by the mortgagee's execution of the sale deed, which guarantees the buyer clear title to the property free from any encumbrances or claims resulting from the mortgage or foreclosure proceedings. The mortgage transaction between the original mortgager and mortgagee is terminated when it represents the legal transfer of property ownership to a new owner. Thus, the sale deed is the key document that facilitates the transfer of property ownership after foreclosure. Its execution protects the legitimate interests of all parties involved in accordance with the prevailing legal standards and ensures compliance with the legal requirements. In conclusion, we can say that mortgages are transfers on immovable property which do not transfer absolute interest in the transferee, but only limited interests depending upon the type of mortgage agreement both the transferor and the transferee have entered into. The transfer is accompanied with a wide range of rights and liabilities bestowed both upon the transferor and the transferee, and thus indicates the clear extent of rights attached with the piece of land under question. This was all about transfer of property subject to mortgages. See you in the next lecture. Till then, thank you and goodbye.